Good morning, everyone. My name is Kathleen Cardone. I am the chair of this committee to review the Criminal Justice Act. We're going to get started this morning. Before we do, I'd remind everybody that if you have any cell phones or iPads or anything, to please get those silenced so that they're not disruptive. The session is being broadcast live at cjastudy.fd.org. And for those of you, and I think a number of you have already had the opportunity to look at it, but it also, we have hearings that are archived, so if any of you want to go back and look at any of the information, if any of the public wants to submit comments, you can do so by going to cjastudy.fd.org. We're going to get started this morning with our first panel, and I just want to say before we get going, we had a session all day yesterday, so I'm not going to say too much other than we are a committee that was appointed by the Chief Justice. We are on a 2-year plan to submit a written report regarding our findings, and so these public hearings are being conducted throughout the United States. We've already had hearings in Santa Fe, New Mexico, Miami, Florida, Portland, Oregon. We're today here in Birmingham, Alabama. And we have 3 hearings left in San Francisco, in Philadelphia, and in Minneapolis. The committee is here, and we will begin this first panel. The panel participants are Ms. Debbie Hunt, who's the clerk of court in the Sixth Circuit, correct? Judge Jane Malazzo from the Eastern District of Louisiana, Judge John Ott from the Northern District of Alabama, and Magistrate Judge Clifford Shelley from the Eastern District of Tennessee. So with that, the way we're going to proceed is we'll let you make a brief opening statement. Please do not read from your submissions. Everybody's had an opportunity to look at those, but we'd ask you to make a brief opening statement. Once those statements have concluded, we'll begin questioning by the committee members. And again, we want to thank all of you for being here. We very much appreciate that. So why don't we start with you, Ms. Hunt?
Thank you, Judge Cardone. I want to thank the committee for allowing me to participate today in this very important national conversation. Chief Judge Cole had asked me to appear today. I think it's on.
Yeah, just make sure
better?
And I will tell all of you, it is being recorded, so speak right into it.
Chief Judge Cole has asked me to come speak to you today on those issues that where the clerk's office and administrative matters intersect with CJA. In the Court of Appeals, that is primarily in both panel management and voucher processing. It's also in case management, since, as you know, in the Court of Appeals, most cases are managed in the clerk's office before they are submitted to a panel. So panels come into the case fairly late when they are ripe for decision. So my office deals with appearances, getting attorneys appointed, getting transcripts prepared, briefing done. The minor housekeeping motions are handled exclusively in the clerk's office, of course, with the chance of appeal to either a single or 3-judge panel when they don't agree with our initial orders. But that's primarily where we're interacting with appointed counsel, either CJA panel counsel, FPDs, et cetera. Our death penalty work is fairly robust. We have the death penalty in 3 of the 4 states in the circuit. Michigan does not have a death penalty. Ohio, Kentucky, and Tennessee do. Ohio has a fairly substantial number of individuals who are under sentence of death, and our the primary source of our capital case docket is from Ohio. So we deal quite a bit with the capital habeas units, which are, I believe we have 4 capital habeas units in the circuit, 2 in Ohio, 2 in Tennessee. In Kentucky, we have mainly appointments from the Public Defender's Office there, which is the Department of Public Advocacy, in capital cases, this is. And then in Michigan, we have only the federal death penalty. We do have 1 active appeal from a federal death penalty case right now. The quality of counsel in those cases is, from my perspective, I look at quality in terms of whether they are compliant with the rules, whether they're able to process their cases properly, whether they get their things done on time, what we can, and also to an extent, what we can do to facilitate their work. We obviously, when you're working with professionals who do it all the time, such as the Capitol Habeas Units and the Department of Public Advocacy, you have people who know what they're doing and are familiar with the rules, who understand the procedures. This is true of also non-capital cases. We find that those members of our panels who have a deep experience with appeals in particular are generally going to process their cases more timely and more effectively. The Sixth Circuit does have, not unique anymore, but was one of the pilot courts for the case budgeting attorney program. We work with the case budgeting attorney who not only budgets cases throughout the circuit that are either death penalty cases or mega cases, he also assists with the review of excess vouchers in the circuit, and the judges are very appreciative of his efforts with that. He is going to be testifying next month in San Francisco, so I won't speak to his functions other than to say that it's been very helpful to both as I understand it from feedback from the attorneys from my office and from those judges who deal with him, the excess voucher processing judges. The Court of Appeals recently adopted e-voucher. We were one of the first courts of appeals to do that. We are hopeful that it will reduce the amount of resources that we have to expend in both panel management and voucher processing. We are encouraging the rest of the district courts in the circuit to do so that we can have access at some point to a fairly robust data system. We plan to use it for any number of things, to provide for our judges information for our judges, to manage our panel better, to have a better handle on that. I was able to use it yesterday. I listened to the streaming testimony yesterday, and I was able to use it to look to our last 7 months or so while we've been on the system, and also to look to some reports that we generated in-house for the past 2 years to determine how many vouchers had seen a reduction. And I should have written down the actual number. I didn't. I think there were about 40, there were a little over 40 vouchers that had seen a reduction. That constituted about 3.5% of all vouchers that were submitted had some reductions. I did not have time to go look at those and see what they were, and whether there was a response from counsel and whether the reduction actually held. These were based on reduction letters that were sent out. I am happy to be here again today and offer any administrative point of view that you would like to hear from the Court of Appeals. Thank you.
Thank you. Judge Ott?
I also appreciate the opportunity to be here.
I'm not sure your microphone is on. Is there a green light there?
Yes.
Okay.
Now, appreciate the opportunity to be here. It's my understanding we have submitted, and I have read the materials that this court provided the committee in written form. Also, Judges Putnam and Proctor were here, I believe, yesterday and testified or provided information. I do not have a specific opening statement to make because of that. However, I do welcome any questions at the appropriate time.
Thank you.
Good morning. My name is Cliff Shirley, Chief Magistrate Judge from the Eastern District of Tennessee. It's a particular honor to be here and be in a building named after Hugo Black, who was actually a friend of my family years ago, even though I'm a Tennessean now. But I've been on the bench 14 years and practiced robust civil litigation for 25 years. I have not only read all the reports and seen a lot of the videos, but I've had occasion to review the qualifications and the resumes and the CVs of those who have spoken the panel here as well. I confess to not having a similar pedigree in this area, just experiential knowledge, and but you shouldn't translate into me not having a lot of opinions, which I do. I'm also thankful for this opportunity because that effort caused me to reflect on my own work and reevaluate, reexamine, take some of the critiques to heart already. Didn't agree with them all, but it did give, as I told Judge Cardone, cause to pause. And so that's been very helpful to me. Let me just say as my opening statement that the biggest problems that I see in a macro sense are the large number of prosecutions, the number of large prosecutions, which I mean by multi-defendant cases in our district. That would be, several 40 plus, a couple 60 plus, 101 defendant prosecutions, which obviously takes its toll in a domino effect, not only on panel availability, but panel cost, travel, and the things you've probably heard all about. The third is the large amount of e-discovery, electronically stored information. We are now up to terabytes in our court. Gigabytes was terrible enough, but when we exceeded that into terabytes, I don't really know what management of a terabyte of information looks like. We're trying to get our hands around it, but it's a little like warm Jell-O. The other issue that doesn't get a lot of talk and may not be an issue in a lot of districts is remote detention. And that really exacerbates the costs. And then there's finally this last issue that may be kind of at the underlying core of all of those, which is, for me, what I call the typical criminal drug defendant. It seems to be a younger person, 25 to 35, who shows up with 2, 3, or 4 prior state felony convictions, each of which his or her state lawyer was successful in getting reduced sentence-wise to probation, then serious probation, then enhanced probation, then we really mean it probation. Bottom line is this person has never served a minute in prison, and they walk into a system and they hear me or the assistant United States attorney say, by the way, because of your record, there's a minimum mandatory of 15, 40, or life. Well, first off, that doesn't really help with the detention problems we're having pretrial, because the way the Bail Reform Act is, that person has a pretty hard time being released. Well, if they're not released and they get sent to remote detention, we start out the cost being escalated from day one. If I have a lawyer who's already out of town from a different direction going to a remote detention, and by the way, we're in East Tennessee, and 2 of our remote facilities are in western Kentucky and at the Florida-Georgia line in Valdosta. So you can appreciate that sometimes the travel costs exceed the substantive cost of bills. Now, I don't know if there's anything we can do with that, but that strikes me as the main issues that I'm seeing today. Let me talk just real quickly about the things that I think have been the hot topics, which have been things like the hourly rate, judicial review of those bills and things like that. For me, the hard thing getting my hand around is what you do in terms of a comparative analysis for the hourly rate. Okay, $129 an hour seems awfully high if you are a state-appointed lawyer. In fact, it's 3 to 4 times what they get, which is abysmal, by the way, but still. If you're comparing it to a top civil lawyer in our area, it's quite low. If you compare it to the average hourly rate of a solo practitioner, of which most of our CJA lawyers are, it may be about right. If you were to take an AUSA's salary and reduce it to an hourly rate, even after factoring in overhead, it probably is fairly, even. It must not be too bad, as we have a large number of people seeking to get on the panel every month. So there's more people seeking to get on than we're allowing. Another pragmatic way to look at it is whether the average person, and whatever that is, could afford to pay $130 an hour to a lawyer, pay $10,000 cash to a lawyer. And the last, I guess, thought I have on comparative analysis is, we only have one fee, one rate, whereas virtually every firm has tiered rates. So the question is there a certain irony that comes from the fact that the least experienced of our CJA lawyers, who take the most time to do the same matters that an experienced lawyer who provides better quality, if you will, and the less experienced gets paid more than the, quote, better lawyer. I see less issue with the hourly rate than with the max rate. Given the things I talked about earlier, the travel, remote detention, the ESI, the breaking of the max level has become the rule instead of the exception to the rule. If you think about, with the gigabytes of discovery, if you just had 500,000 documents, I say just, that seems like a lot, but in this day and age, that's not. If you reviewed 1,000 an hour, that'd be 500 hours. You're already at $64,000. If you just reviewed 20% of those, you said, I'm just going to review ones that might relate to my client, that'd be 100,000. If you did those at 1,000 an hour, you'd still exceed the max. You'd already be up at $13,000 just for reviewing documents, 20%. The other problem I think that I haven't heard anybody talk about is the overall case costs, not on a per defendant basis or per lawyer basis. But what are these multi-defendant cases costing? If you have just 50, which is half of one of our multi-defendant cases, if you just had 50 lawyers and they all just billed the max, that'd be $500,000. If they all billed $10,000. I don't know what one does with that, but I just think that's something ought to be considered as well. You'll hear me talk, if we get to question and answer, about judges, that I'm the contrarian. I believe judges reviewing bills is quite fine. I did timesheets for 25 years. Not every judge did, though, and I think that some of the suggestions about training for best practices on billing and billing review would be good. But I even reviewed bills for of other lawyers around the country. It's not that it's the greatest thing. I understand the criticisms and critiques, and I've taken some of them to heart. But it's a little bit, I guess, like Winston Churchill said about democracy. It may not be that great, but it beats all the other alternatives. And with that, I mean, it sounds like the only two alternatives I've heard are having the federal defenders do it in-house, which would be incredibly burdensome, it seems to me, both time-wise and cost-wise, in a time when they're already strapped time-wise and cost-wise. Or it would be setting up a third party billing examiner. before one went to that extreme, one might want to talk with civil lawyers who over the last decade have been involved with third-party billing reviewers. And I think you would hear that not only has that been an abysmal experience, but they are quite despised. One of the questions that I haven't heard answered if you were to set up such a other program would be who would monitor them, who would supervise them, who would they answer to, who would pay their salary, their staff for their offices. The real issue, I think, arises with anybody else is where's the incentive? Would the incentive be for a third-party biller to cut to justify the fact they've been hired and are being paid this money? Or would their incentive be not to cut because they're replacing judges who the complaint was they were cutting too much? And if they're not cutting any bills and they're just rubber stamping them or approving them, why do we need them? And why do we need that additional cost? So I'll be glad to answer and expound on any of those. Thank you again for the opportunity to be here this morning.
Thank you. And Judge Malazzo.
Good morning. Thank you for having me. I actually had no prepared statement, but I do just have to respond to something Judge Shirley had, because I have to tell you we are unique in New Orleans in that the federal defender does provide, coordinates the review of vouchers for the judges and presents us, and so we work very carefully with them. And while it is indeed a strain on the federal defender's office, we find that there is more uniformity among the divisions of the court in that we have the same person acting as mediator, and very frankly, I think it functions well. We have, I believe, excellent representation provided by the CJA panel, and the panel positions are very competitive. People want to be a part of the panel because I think the billing has not become problematic as a result of our use of the Federal Defender's Office. With that, I have no further comment and welcome your questions. Thank you.
All right, our original committee members included Mr. Chip Frensley. He was unavailable, so Mr. Neil McBride is acting in his place. We have on the committee members Judge Mitchell Goldberg, Professor Carr, and Catherine Rowe. And we'll start with you, Mr. McBride.
Great, thanks, Judge Cardone. So I wanted to start with some questions about voucher cutting, which several of you mentioned. And Ms. Hunt, I'll start with you. You had said that, I believe, last year your data showed that there were about 40 vouchers that were cut, and if I understood you correctly, that was about 3.5% of vouchers submitted. So just a couple questions about that. I'm curious if you have any historical data and can compare that to prior years, whether that's more or less a median or mean average, or whether last year was more or less than what has been seen in recent years?
Well, it was a 2-year, that was for a 2-year
2
period
years.
of time.
Okay.
So it goes back, it was 2014, 2015. I could probably get some historical data, but as I said, I did not have time yesterday. It wasn't one of the issues that I had been looking to discuss, so I just did it off the cuff, and that was, I had raw numbers, but I didn't have anything further back than that. But I can get it if the committee would like that. I'd be happy to supplement.
And in terms of, I don't know if you have this sort of insight or granularity, but any sense either from analysis or I guess anecdote as to the reason for those cuts? In other words, we've heard from witnesses over the course of our hearings that, in some districts, a percentage, a material percentage of voucher cuts may be sort of ministerial, some sort of, mistake in transposing numbers or something like that. In other districts, we've heard it's much more sort of a, substantive disagreement by the reviewing magistrate or the judge, where they just think, the cost of the case is significantly less than what the lawyer put down. So any sense as to what in your district has been recently a small number of reductions, what sort of which buckets of reasons for cut those fall into?
I don't really have any insight into that, since I did not look at these personally. I didn't see them. We do technical reviews of all the vouchers. We do catch errors, so that could account for a good portion of those. I think eVoucher is going to be much better at catching those before they get to a judge. I do know that when the judges have questions about the substance in a voucher, the case budgeting attorney is frequently asked to weigh in and review the voucher. So,
And you know, Ms. Hunt, how, just using the last 2 years as an example, any sense of how your circuit compares and contrasts to the other circuits?
no.
Are you aware whether the AO keeps data by circuit?
I don't know if they do or not. I would have to find out. I mean, these were reports that we kept in our ECF system. So we were able, this is data we kept there, so we were able to generate it. Until last July, we were on 6X, the old system. So anything we had was either with paper notebooks that we kept, and we would generate information manually, or through CMUCF. So I doubt that there is a comparative database for that, although there might be. I don't know. I don't quite understand what the data possibilities are in 6X.
Right. And the, just the last question, the numbers we've been discussing for the last 2 years, is that data that the circuit in turn has reported in any fashion to the AO? Do you know if they have that information?
This was literally off the cuff. I went at about 11 o'clock yesterday morning when I was hearing the discussion and asked my staff to look at it and try to pull that information for me for 2 years. What I can say is I don't hear, and I do hear attorney complaints somewhat about things. I don't hear a lot of complaints about voucher cutting from our attorneys. And again, it may be that I'm just not the person they're turning to, and I guess Chip and Mike Mazzoli might have more insight into that. But that's not a complaint that is registered with me when I go out to speak to the bar or when they call in with an issue.
Right. Okay. Judge Shirley, a couple questions for you, since you talked about voucher cutting in your prepared remarks and this morning. So it sounds like you personally, over your 14 years of service to the district, from your perception, at least in terms of the vouchers you're reviewing, you have not been in a situation where you've had to do much voucher cutting. I wonder if you could speak a little bit about the instances where you have had to do it, again, trying to sort of break it out in buckets or by rough percentages as to, what sorts of things, in your view, required, the cuts in the cases you've seen over the lifespan.
I would say that they come in two batches. One would be the ministerial, mathematical, transposing areas that you mentioned, and I think I mentioned in my prepared reports. There's just errors. The other is the acknowledgement that not all CJA attorneys, love them as I might, as important as they are saints when it comes to billing. And that can be either through lack of experience, or it can just be the fact that excessive billing does exist. And one has to acknowledge that. Sometimes there are patterns of unreasonable billing. Now, in my case, I put some of those in my remarks, I think in a footnote. And they're few and far between. But when you look at someone who has filed a sentencing memorandum and they have billed the average, 8 to 12 hours for preparation, research, and whatnot, and then you go back and look at their past 6 sentencing memorandums and they're the same, with the exception of some, looks like a macro fill in the blank. Well, my experience, I call the lawyer on that. I tell them I'm cutting it. I don't want to see it again, and they don't have a problem with that. And I had a problem with them doing that. if you see somebody that regularly, for whatever reason, seems to double the in-court time. They're in court for half an hour, 3/4 an hour, and their bill shows an hour. They round up or whatever every time. That's something we can check. So sometimes it's what I think is looking at certain things. Realize the reason there aren't a lot of voucher cuts, and I don't think there's a lot of questions, we can't even begin to cut most of the entries. How would I know how long it took them to meet with their client? How would I know how long it took them to do certain substantive work or to review the discovery when it says review a gigabyte of discovery? I can't second guess that. But when I have 10 lawyers in a case and they're all coming to Knoxville from Chattanooga and they're all billing within 5 miles, let's say, or 10 minutes of time the same, and one's billing an extra hour for travel time for every trip, that's hard to explain other than that's a systemic problem with that lawyer. So they come in two kinds. One I think is a little intentional, one is unintentional. I will say this, I make it a practice to try to pick up the phone and call those lawyers, or next time they're in court, actually have them come back and I talk with them. And I have had all but one ever just basically say, sorry, I'll not do that again. So.
Judge, thank you, Judge Shirley. If I could follow up just with one further question for you from something in your written testimony that caught my eye, where this is under, I think, issue 3, and it's the last paragraph before you get to issue 5. But just that last short paragraph, you write, "The biggest problem I've seen with the issue of experts and investigators has not been the overcutting of requests, parentheses, our division has only reduced 2 in each of the past 2 years, paren, but the underutilization of requests by CJA attorneys." And I just, that struck me, I want to make sure I'm understanding you correctly, are you saying that from where you sit, you and your colleagues, you believe there are instances when CJA lawyers might be raising their hand to ask for an expert or investigator and they're just not doing it for whatever reason?
No, what I meant by that was, as I read through the reports and I listened to testimony, there seemed to be a lot of complaints about the judges reviewing CJA 21 vouchers for experts and things like that, and whether they were imposing their will on how a case was tried and things like that. There just aren't that many requests, the gross number in our district for those. And what I meant was, from my standpoint and my watching and knowing how I tried cases, it just seems like the use of experts, the requests for experts, the request even for investigators, the request for any assistance, paralegals in complex cases, is underutilized. They don't ask for them. And that has surprised me, and I hadn't thought a lot about it till I was going through all of this and realizing that in our district, at least, say I have a 50 defendant case, you would think I would have 50 requests for certain things, and I have 5.
I know it calls you to speculate, but any guess as to why CJA attorneys in your district are not making those requests?
No, and it certainly isn't because they've been turned down. Because I handle those first, and it's not because they have to disclose much. They're pretty cryptic requests, and I rarely think it's appropriate for me to second guess somebody on those issues. No, so I don't really know. And again, mine is anecdotal, much like my criticism of some of the others is anecdotal.
Judge Cardona, if I have time for one last question.
Go ahead.
Judge Malazzo, we heard yesterday from your FPD, Mr. Kelly, who came and shared about the model you just summarized. And some of us, certainly I was very intrigued by that. We've heard, a number of different structures and models across the districts, circuits that we've talked to so far. And Mr. Kelly made an interesting observation. I asked him whether he thought the model in the Eastern District might be a good model that other districts, might look to. And his question was, it depends a little bit on how, the committee and the judiciary ultimately sees the federal defender. If my job is to, help manage the CJA panel in an efficient way, so I think we do it very well. The downside would be it tends to distract from my ability to fully focus on and execute the mission of the FPD. It drains some resources away. It'd be nice if I could be held harmless by giving a couple of resources just to manage that. But then, and these are my words, not his, it might be the best of all worlds. So the question for you, Judge, is to the extent that you, at conferences like this and your circuit conferences, the all-judge conferences, to the extent that you sort of compare notes with your colleagues around the country about these issues, do you have any view, do the judges in your district have any view, even informal and off the record, as to whether the way the panel and the defender are sort of integrated in your district is a best practice, or any sort of practice that might work well in other districts?
I have to be frank with you, Mr. McBride. I am 4 years on the bench, and it never occurred to me that it operated any other way. So this was very new to me, and when I was asked to fill in at this hearing, I met with Mr. Kelly, members of the CJA panel, and called in some other colleagues to discuss these issues. And that's when I learned that this is not how it happens anywhere else. I can tell you that our chief judge has taken the position that this, I can't imagine, very frankly, having to deal with every voucher and reviewing the billing very specifically on every case that I have a CJA panel attorney representing. It works very well for us. I have no experience in the other way. I can tell you that our judges would have no desire to move from the model that we have in place. And I can just anecdotally tell you, there was one habeas capital case in the Eastern District, and I won. I drew the short straw, so it's mine. And it was very comforting for me that as soon as that case was allotted, to be able to call Barbara Daigle, who is a paralegal in the Federal Defender's Office, and to meet with Barbara at that time to speak to how we were going to manage the budget to be submitted to the circuit. And then after, when the lawyers that were actually appointed visited with me, I had already reviewed it all with Barbara, and she really works as an effective mediator to avoid I think, the inherent conflicts that arise in any other way of handling it. So all I can tell you is my experience has only been this, but I can assure you that in our district there is no desire to move from the model that we have in place.
Thanks, Judge.
All right. Judge Goldberg?
Ms. Hunt, good morning.
Good morning.
Do you have your prepared remarks?
I do.
Okay. I wanted to make sure I understood some statistics that you've provided us, and thank you for doing that. The table number 2, CJA vouchers processed by the Court of Appeals, that table. And I'm interested in the CJA 21 expert services. For 2014, the number is 6, and 2015 it's 6. So I want to make sure I understand what that means first. Does this mean that these are the numbers of the circuit vouchers that have been approved that are over the statutory limit of $2,400? Is that what that means?
No, what that represents, the CJA 21 expert services, is vouchers in the Court of Appeals, not from the circuit, not excess vouchers.
Not excess vouchers.
Not excess vouchers from the district courts. This is strictly vouchers concerning appellate cases in
Just
the
appellate
Court of
cases.
Appeals.
Okay.
And those are
that's good.
mainly translation providers.
Okay.
There's not a lot of need for expert service at
Is there a number here that would tell us how many, for those 2 years, 2014 and 2015, were excess vouchers approved by your court?
Actually,
The circuit.
the expert vouchers approved by the circuit is in chart number 3. Chart number 3, we approved, but this isn't expert services, this is just the number. We lumped together all of the excess vouchers, so that is not broken down. I did not break that down by CJA 21s, 24s, or 20s.
Okay, thank you. Judge Shirley, I thought I heard you say that the state rate, the CJA state rate was half of
Yes.
what the federal rate is?
Yes.
What is it? What is it?
I can't remember, but I think it's $50. It may be more than that now, but it's terrible.
And understanding you're a federal judge, I'm stunned by that number. How do?
I just hear that,
Yeah.
okay? I mean, I'm not over there practicing, but
Yeah.
that's what I've heard, and I've read some stuff, so I couldn't speak to it, but I can pretty well be assured it's not, remotely approaching even 100. You can appreciate the state defenders who want to come over to federal court.
Right. And in your prepared remarks, you talked about, I think, and I want to make sure I understand, it's your view that the CJA lawyers, understanding everyone would like to have a higher number, but that they're satisfied with the federal number, 129? Is that your view?
I've never had a conversation with them regarding their satisfaction with
Right.
that number. All I can say is those who are on the panel, I don't recall anybody having even commented about leaving over the rate. And there's a line waiting to get into the system to get that rate.
I think you commented that it could be just general numbers, but when you crunch in the hourly amount of time for these cases and overhead, it's sort of commensurate with what a private attorney would charge?
Again, it would depend on what your comparative analysis is.
Yeah.
If we review civil billings all the time.
Right.
And so.
Let's take a
300
felon in possession, simplest
Perfect.
felon in possession case.
Example is $300 an hour is pretty much our max in our area. Now, much higher in other areas, I'm sure, but $300 an hour. And that's a top
Civil or
flight.
criminal?
Civil. Top flight civil lawyer in a complex case. Fee shifting type of a case. So I think that particularly with the situation law practices and firms have been in the last 4 years, I would say those who get $200 an hour regularly in our area aren't hurting too bad. So 130 is probably on the low side of reasonable, is what I'd say.
That's what I was trying to understand. There's so many interesting parts of this assignment, and one of them is just to understand the differences between the different districts and circuits. So can you give me a sense for, let's just pick a felon in possession
Okay?
case for a private attorney, what would be the hourly rate?
I don't know.
Yeah.
I don't know. I've never been privy to that. I've always wondered. I didn't do retained criminal practice, and I always wondered what they do charge. You might hear things on the street, but you have no way to know. But I have no idea.
You think it's a little higher than 129, or?
I don't think it's an hourly rate. I think what I hear is I think they get what they get the first day in a lump sum. They get paid a flat fee. If I were guessing, I would guess it'd be between 10 and 20,000 for a
Okay.
retained lawyer. I don't know.
And can I ask you to speak into your microphone?
Oh, I'm so sorry again. I leaned back.
That's okay.
My eyes are so bad I can't read you. How do you pronounce your name, Judge?
Milazzo.
Milazzo. Could you elaborate a little bit on your use of the public defenders with the vouchers and tell us in a little more detail how that works?
Our public defender's office, as I appreciate it, there is one paralegal that is virtually assigned to the CJA panel. And I don't think it's a formal assignment, but because of the significance of the time that it requires, she does this almost full-time, and she reviews all of the vouchers. When there's a suspected voucher, she will call the attorney in, meet with them, and basically serves as a mediator between the attorneys and the judges. And when we are presented vouchers,
I'm sorry, this is a paralegal?
yes. And it's an administrative position, and she reviews it. By the time a voucher is received by me, it has been reviewed by the by Barbara in the Federal Public Defender's Office. She reviews the math, sometimes calls them in and will question certain items on the voucher, and it's usually completed by the time it's received by the judge. If there's further questioning, we can call the attorneys in, but I think she cleans up any excess billing by the time it's received by the judge. So someone else has looked at it. She has served as that third-party review.
Do you see situations, and understanding Judge Shirley described them as infrequent, but do you see situations where does the paralegal address situations where there's been 3 hours of court time and in reality, but the bill says 5 hours?
That's what she does.
Okay.
And so I'm not having to review all of the vouchers to make any sort of comparison. By the time, frankly, I get it, I'm very comfortable. I can look at it, and I've not had any problems after her review.
Do you have any sense as to whether the attorneys have any resistance to, I'm not denigrating the title of paralegal, but a paralegal question their billing? Has that ever been a problem?
Not really. I think what you have to look is at the experience that Ms. Daigle brings to the table. She's been in the Federal Defender's Office longer than anyone else. And so she has done this for years. She's very experienced. And I think it's a model, as I appreciate, that they enjoy, because they've worked with her for years. And then there's a uniformity in the divisions of the court. That's it. You know, they know exactly what's going to be accepted and what's not accepted, and they're not dealing with one judge who has an attitude that no case should cost more than $5,000 and another judge that won't look at any of the billing. And so I think, frankly, that becomes more problematic in this situation. They can go to the Federal Defender's Office, they work with her, and she mediates so that there is consistency across the board. And I can tell you, in some of our more complex cases, it was easier for me to contact the Federal Defender's Office to say, I know there's going to be a budget that's submitted by the attorneys. Are you going to review it ahead of time? And then to work with her and the attorneys. I think it just becomes a better model. But that's my only experience, so it's really hard for me to complain about or to critique any other model that I have not had experience with.
Yeah, well, this is very helpful because we're going to try to decide if we recommend change. Then the next question is what's the change? What's the model?
The problem is, and I think it's already been articulated. I'm sure Mr. Kelly has informed you that it has created a tremendous strain on his office, but I think the judges in our district are not, or do not want to move from the model that we have in place.
Well, if our recommendations would be maybe more funding for that type of model, and if the Judicial Conference agrees, and then if Congress agrees, maybe we could.
That would be great.
Right. That's why I underscored all
That would be great.
A lot of ifs.
That's a lot of ifs.
Yes.
But that we would be delighted.
Yes. And one more question for you. I just want to make sure I'm clear from your testimony and Mr. Kelly's testimony. The instances where the negotiation, so to speak, between the paralegal and the lawyer, are there any instances or some instances where that breaks down and you have to be the judge and decide, or is that very infrequent?
I've never had that, but that's of course always an option where there is a complete disagreement, but I've never had that experience for me. Now, what has happened is when budgets have to be submitted to the circuit, even after they've reviewed it, there's still a requirement that the lawyers meet with me to advise that this is a budget that has to be submitted because it exceeds, it's just, for example, the habeas capital case that I currently have, even after they had reviewed it with the Federal Defender's Office, before it could be submitted, there was.
That's a great example of that type of case, a bigger case. Do you have any information or advice for us as to the paralegal CJA lawyer interaction when they have to go to the circuit and get approval for excess funds?
What I've done in my situation is call the federal defender, and very frankly, it was Mr. Kelly and Ms. Daigle that came and visited with me, and we spoke about what sort of budget and how, because I very frankly, this was new, and they had the experience. We went over what the process would be, and then they asked the attorneys appointed to submit to them a budget, and then they worked through it, and then it was submitted to me at that time. They were able to work through it. So while I had to approve it, by the time it was presented to me, it appeared to be reasonable. I was satisfied, and then as the vouchers, it just has worked.
Thank you.
Professor Carr?
Thank you very much for your testimony. One of the complaints, sorry,
I can't,
back here,
I thought, where are
the
you?
voice, I can hide under the desk if it makes it even more mysterious where the voice is coming from. I wanted to ask a question related to voucher cutting questions. One of the concerns we've heard about voucher cutting has been based not so much on line-by-line review of whether there was an error or some reason sort of objectively to think that something was entered in wrongly, but rather a sense that there should be there's an inherent value almost in a particular kind of case. A drug case is likely to be X dollars, or a gun case is likely to be Y dollars, and that somebody who's billing beyond that really shouldn't be. And I'm wondering if you have any reaction to that sort of a judgment, if you think that's proper, improper, and more broadly, if you think it would be helpful for there to be standards written into the law or guidance as to exactly what kind of voucher cutting is appropriate or inappropriate and under particular standards, or if it's okay to leave it something more general and something maybe applied a little bit differently in different districts or by different judges.
I don't share that there's any value assigned to a particular type of case, and I think one has to be very careful with that. Sometimes you will have a multi-defendant case, and the billings will seem to be in reverse order. Say the kingpin or the leaders' bills will be the least, but they may have adhered to the federal rule, unwritten rule, first to plead wins. Whereas the lowest delivery person may not have had a chance to cooperate, and they had to go to trial. So that bill ends up being the highest, which would seem not to make a lot of sense if you just assigned values based on either culpability or sentence, things like that. So I'm very reticent to say that a certain case or a certain type of thing is worth a certain value. I would say this, I wouldn't mind if they had two different maximums, one for single defendant or two defendant type cases or whatever we might call it, a general case, and the ones for these multi-defendant or complex electronic discovery cases, because they bump up against the maximum within weeks sometimes. And with the motion practice, they need to keep up with what the other defendants are doing, particularly what are they doing to my defendant, and the costs that are involved maybe with remote detention. So I wouldn't mind if there was a second tier of maximum so we didn't have to always bump up against them, because, and I am curious about one thing, I don't know if I'm allowed to ask questions, but I like the idea of the federal defender being involved in the process. There's probably no judge here that's testified before you wouldn't mind giving up voucher review in a heartbeat. But I'm curious, with all the multi-defendant cases that we have, and one of them being the federal defender, how do they review the bills of the other defendants? Is that not a conflict problem greater than the concern about the conflict of a judge, particularly if it's up front? Do you know what your co-defendant's expert is going to be? That was my concern with them doing it from a legal standpoint, besides just the cost value. And
I think Ms. Rose district does something similar to that, so maybe when she gets her turn at the mic, she can engage you with that.
that's fine, and we don't have to do it on the air, so to speak. I'm just curious about that. I don't know if that answered you, Judge Kerr. I mean, Professor Kerr.
It's helpful. Yeah, if anybody else on the panel has thoughts, I'd love to hear them.
I would say this, Professor, that I have probably reviewed in 18 years close to 2,000 vouchers, because the magistrate judges of this court are the reviewers of the substantive billing. The percentage where there is inappropriate billing for technical other reasons, way less than 3%. The CJA lawyers do an absolutely great job with that. When there is a question, however, usually it is technical or just an error by the lawyer. If it is truly a substantive issue, by way of example, a lawyer recently was billing 0.2 for every email he was sending out, and he was sending out tons of emails in this case, and it was a big case. I called him up and said, is every email taking you 10 or 12, 15 minutes? He said, no, I just chose that. I figured that was the appropriate thing to do. And I said, well, if it's 5 minutes, then bill accordingly. And he was like, okay, thanks. I'm glad someone told me. So I want to be sure that everybody understands we review a lot here. They do a great job with it. Having done that many, I would say this, every case is absolutely different. Having reviewed that many, do I have a gut visceral on what an average 922 defendant should be or probation revocation should be as far as cost goes? Absolutely. Do I look at everyone independently? Yes. I have the same concern Judge Shirley does about the federal defender does not do them in our district. I'm concerned about a conflict there. Number two, knowing the lawyers in my district as I do, because I've been practicing here either as a law clerk, prosecutor, or as a magistrate judge for 35 years, I would be very surprised if the CJA lawyers that we have, the quality and caliber they are, would like their work reviewed by a paralegal first. A judge is very different. If I call them up and ask them a question, they don't mind answering it. We'll have good discussion. It's over with. I would also say we have the same problem Judge Shirley does about remoteness of defendants. It's hard to come up with a plan when the defendants are all over the district. So I hope that answers your question.
Just to follow up on that, on the conflict issue that you raised and Judge Shirley raised, I know if it would go from a paralegal, the review, to a defender, a lawyer, some of the closest friendships I've observed in our district are between the defenders and the CJA lawyers. Query whether that's a good model, having friends reviewing each other's bills and affecting each other's livelihoods. So I think you both raised excellent points in that regard.
And when I bring that up, as Judge Shirley does, I in no way am impugning Mr. Butler. He is absolutely incredible. We're very pleased with him. I enjoy working with him on a regular basis, but I am concerned about perceptions there.
And mine's the same. Miss Beth Ford, who you'll hear in the next group, has no peers, but she is the biggest supporter of our CJA lawyers, as she should be. And I'm trying to protect her, actually, and keep her from having to take on even more when she needs to, not have more.
So this has been helpful, and I wanted to ask what I think of as kind of the standards question, which is, one approach is to leave the question of voucher review as just an open-ended issue. Each judge can review that judge's sense of what is reasonable or not reasonable. And one consequence of that may be that a particularly excellent judge will be particularly excellent in reviewing a voucher, and a judge who may not that day be so excellent may not be so excellent in reviewing the voucher. Would it be helpful in your view if there's more guidance in what the standard should be? So for example, I think Judge Shirley, you were saying, there's some things, of course you wouldn't cut for that. You can't make a judgment call about certain things. Other things you can make a judgment call about. And, I think your sense of what you could do and not do seemed absolutely sound to me, but I wonder, would it be helpful if something like that were codified to the extent there may be some judges that are not following that guidance?
That's addressed to me. I think my only thoughts, is, if I'm understanding what you're saying, is I would encourage training both ways. I suspect there's a lot of CJA lawyers who aren't used to regular billing, keeping a timesheet, that type of thing. And this may be the only types of cases they do them in. And so they could use some training. Judges who don't come from a civil background and regularly live with a timesheet permanently attached to them may not understand incremental billings and things of that nature and how that works. The other thing that would be nice, and I'm going to probably recommend this when I go back, I made a note to myself, maybe have a brown bag lunch with the judges and the lawyers or the defenders, have them set up something and talk about the various issues. I mean, I think we're pretty open, and I don't mind hearing from them about what their concerns are and expressing to them what our concerns are and what we look at and what troubles us and what troubles them. And I always believe that more communication is better than less. So I would hate to ever go on record as recommending codifying one more thing. But I would agree that relationally, things can probably be improved.
I agree with Judge Shirley on that. It's hard to codify. By way of example, if you were to codify, you should go see the defendant once a month or once a week. Some defendants do not require that. Other defendants may require more than that. So I'm afraid of codifying or standardizing any of it. I think it's working, as far as I can see.
Ms. Rowe?
Ms. Hunt, I'm going to begin with you. Ms. Hunt, the information that you gave us about the voucher reduction for the last 2 years, you said, was 3.5%.
Yes.
Can you tell me if that includes the excess compensation vouchers?
No, those were strictly our Court of Appeals vouchers.
All right, good to know. So that would be essentially, looks like the excess compensation vouchers for 2014 were 1,027, according to your chart.
That's right.
Chart number 2, or table number 2, and 1,137 in 2015. So that does not include those.
No.
So as far as the excess compensation vouchers, the ones that come up from the district court, do you know the percentage of cuts on those vouchers?
I do not.
Thanks. Is that information, is that the type of information that your staff could also gather if they were asked?
I've made a note to see if we can do that. The difference here is that the excess vouchers that come up from the district courts have historically been paper. I mean, right now, we're still taking paper vouchers from the district courts. The only way I know of would be to go back to the notebooks that we keep on those. So I'm not sure, it would require a hand culling if we have the data to cull. So I'm not holding out a lot of hope, but I'm happy to, I've got a note to
Because
see if
I-
we can do that.
Imagine it was a substantial amount of work just to get the 600 plus information from the vouchers that were Court of Appeals only.
That was easier because that was in our system. So we could look to that. We have our own system, you know, our filing system actually had some data points that we could look to for that. But we don't have access to the district court's filing system, so.
And you indicated, I believe, that the way that you determined this was to look at the letters that went out to
That's right.
the attorneys saying, we've cut your voucher.
That's right.
Do you have the same type of letters for folks that you send out for excess compensation vouchers that were cut?
Those, I believe, are going to come from the district court because the district court has already made a decision on those and sent them to us. The judge, I can find out for you if the district court sends a letter, or I don't believe we send the letter. I think the district court does.
What if the voucher, let's say that the excess compensation rate just went up to $10,000 on January 1st. Let's say that, but it really did happen. But let's say that the number was $15,000, and there was no cut at the district court, and it went up to the Court of Appeals, so no letter would have gone out at the district court because there was no cut. Went up to the Court of Appeals, and then the court cut it to, let's say, $12,000. Who would notify the lawyer of that?
Again, I think that would be from the district court because that's being processed at the district court level.
So the Court of Appeals would cut the voucher, and then it would return to the district court, and then
Correct.
the district court, it would be their responsibility to notify the attorney.
Correct.
And do you know if that's done in your circuit in the district
I
court?
think it has to be done. I think the attorney has to have an opportunity to respond to the cut.
When you say you think it has to be done, is that because that's the circuit's rule?
It's because that's how we do it. And to tell you the truth, I'm not sure if, I thought it was in the guide. I thought the guide required that there be an opportunity for the counsel whose voucher was being reduced to get notice of that and to respond to it. Now, I could be wrong, but that's my understanding.
Well, my understanding is the guide does suggest that it should be done, but it's not done in some places around the country, which is why I ask whether or not you know if it's done in your circuit.
I have not polled the district courts now.
Thank you. One more question I wanted to ask you is that you indicated that the case budgeting attorney assists the judges when there is some question about a voucher, whether or not to approve it, whether or not to cut it. Do you have any thoughts and do they do that on the Court of Appeal vouchers also?
Yes.
Do you have any thought as to whether the addition of that person in the last, it's been 8 years in your circuit, I believe, whether the addition of that person has lowered the number of vouchers that were cut or made it higher or kept the same? Any idea about that?
I don't. I'm sure Bob can respond to that.
When you say Bob, who's?
Bob Rands is the case budgeting attorney in our circuit, and I think he'd probably have a much better handle on that than I would.
Do you think he keeps that kind of data?
If not, he certainly has the anecdotal information. I suspect that he does keep, at least rough figures on that.
Thank you. Judge Ott, I wanted to ask you a question about something you had said earlier. In your district, the magistrate judges do the final review on the vouchers?
Not the final, the intermediate. The clerk's office, my courtroom deputy, does a review for technical, mathematical challenges. Then I review it for substance, and it's finally approved by the district judge handling the case.
All right, and is it your experience that your review is really the significant one, that you look at all the substantive issues, you compare to see whether or not, whether it's, if you look at position papers or sentencing memos or whatever, is that something you do versus the district court judge in your district?
I do it, then it is sent up to the district judge. He or she, I am sure, does it as well. But I really do a very detailed, as do the other magistrate judges, review of it. If I have questions, I challenge the lawyers.
All right. And does the district court judge ever come back and ask you why you sent something through, if they think that, that person actually thinks that it should have been cut?
In probably 18 years, I would say less than 10 vouchers total out of 2,000 maybe I've done, or say 1,500. So it's rare, but occasionally a district judge will ask me a question. Sometimes I'll pick up the phone and ask them the question, because I think Judge Shirley mentioned, sometimes you look at the docket sheet and it'll say that we were in court an hour. There's a billing for 2 hours. It doesn't seem to make sense. I may talk to the district judge. I may talk to the lawyer, the courtroom deputy. Sometimes they've merged the time they were with the client in lockup. So there's that kind of communication that I have with all the players, including the district judge.
And so I assume in your district it works that the compensable time for time in court doesn't begin until the judge actually takes the bench, correct?
Yes, in court time.
So sometimes lawyers will write down, let's say the hearing was at 10 o'clock, and then their particular hearing doesn't really start till 10:30, goes to 11, they'll write down 1 hour, correct?
Right.
So it's compensable time, it's just not compensable time in that category.
That's why oftentimes I'll talk to the courtroom deputy, who's really the eyes on, or honestly, typically I'll call the defense attorney and say, I've got this variation, and he goes, well, we had to wait, judge was late, judge was in another hearing, whatever it might be. And we're talking a very small percentage where I challenge them, especially with the new electronic system. That has helped immensely in the work I do. I can review them much more quickly.
So Judge Shirley, would you also agree that time doesn't start that's compensable for being in court until the judge actually takes the bench?
Right, and we have the exact same procedure. I have the same, I would say I have the same anecdotal experience as Judge Ott. And so we actually, or at least I, encourage the lawyers to get there early and meet with their client, particularly if it's somebody that's been brought in from some distance. This is a great savings opportunity for you to meet with your client. Just bill it as such. Bill it as time spent before court, and then break down the time in court, because it should match the time in court. That's all, in court time and out of court time. So it's not a question of compensability. It's a question of, getting it right on the voucher. And I agree that e-voucher, as much as I questioned it starting out, has been terrific so far, at least in terms of speed. I treat it like when I first started a fax, it seemed to have an imprimatur that came with it that required immediate response. So it pops up on my screen and it's like, oh, I have to do it now, as opposed to a paper voucher that would come and maybe sit in a stack.
One of the reasons I raised this is because when you were talking about different ways in which you've noticed that attorneys were claiming time that perhaps they shouldn't have been claiming, that came to my mind immediately when you said the time in court, because that's something that's quantifiable, right? You check
Correct.
the minutes. But I review vouchers every day, unfortunately, also, and I see just scores of vouchers over 10 years, over a 10-year period that I've reviewed them, where folks have just put it in the wrong category. And so we have to say, okay, you were there, you do get paid for this, it's just in the wrong box.
Right.
Fair to say? Correct.
And the times I've had problems are when it says 1 hour meeting with client before court, 1 hour in court. And it was only a 15-minute hearing.
And but you also have to check as to whether or not, or when their hearing actually began and when it was.
I will actually look at the minutes themselves, and I look at the calendar, and I'll say, oh, that was supposed to start at 10, and we actually started at 10:30, so you give them the benefit of the doubt. Plus, I give them a benefit of the doubt anyway. If it's half an hour and they build 0.7, you know, what's the difference?
I wanted to ask you another question about when you were talking about final vouchers that you review. And I take it that your district is just like Judge Ott's, in that in your district, the magistrate judges review vouchers for reasonableness and do substantive reviews.
Correct.
All right. And then it goes on to the district court for
Final review,
final review, that's what we'll call it.
for affirmation.
I was going to say affirmation, but I didn't want to presume. All right, so it goes on for final review. One of the things you were also talking about was when you go back and, let's say, look at a sentencing memo, and it looks like the same sentencing memo that lawyer has filed in another case, just kind of fill in the blanks and make it different. Is there any effort at that part to take that person off the panel? Because it seems to me that, first of all, I mean, the issue may be a funding issue. We're not going to fund things that you didn't actually take 6 hours to do. But the second is, why are you preparing the same memo for a client that you're supposed to be representing? So my question is, have those folks been removed from the panel?
Let me see how to answer that. My approach is educational. With that conversation comes the clear understanding that I don't approve of it either substantively or billing-wise, and that I will give them the benefit of the doubt that this was something that hadn't been brought to their attention and will be corrected immediately. Once I can think of, probably it was not, and they are not on the panel.
So, give me an idea. I mean, so one person's not on the panel. Did this happen with more than one lawyer?
Yes, because it corrected.
So it was another person, but they corrected it.
Yes,
They didn't do it again.
right. And these are aberrant cases. I hope you understand that. The vast majority of our panel lawyers are fantastic. But as you bring up new people, and as more people are in line trying to get there, sometimes you let someone in that, you know, doesn't understand quite as well.
Before we leave this topic, excuse me, just one quick.
And I'm not opposed, by the way, to cut and paste where appropriate. I'm not talking about that, because if you're going to cite Booker or something like that, a lot of times you have some standard language. That's fine, I get that. I'm talking about that rare case where you see 2 or 3 that are the exact same page lengths and the same language, and sometimes mistake his for her.
That's ineffective assistance of counsel, as far as I'm concerned.
That's the big concern.
why I'm asking.
As much as it comes up in a billing format, but as I mentioned in the conversation, there's an undercurrent of discussion there.
I'm not disagreeing with the magistrate review model, just seeking to get your thoughts. How do you and Judge Ott feel comfortable that you can do this when you haven't presided over the trial and the actual sentencing, to use the last example?
That we have or have not presided over the trial? What was your question?
My question was, you don't hear criminal trials,
Right.
and you don't hear criminal sentencings, but yet you're reviewing bills for that. And how do you do that? Isn't the person in the room, the disrespected district court judge, in a better position to assess what happened?
Yes, and I would say where Judge Ott may call them and discuss with the district judge, my usual practice is to make a note and say the lawyer has billed for this much time for preparation for this sentencing hearing, let's say 8 hours, and the sentencing hearing only took 30 minutes. You might want to look back at your notes, and it just seems unusual to me. In other words, if I see something, but I'm not going to cut it at my level because I have no idea. I wasn't there. I would certainly not cut any trial time or preparation for trial time because I wouldn't have been involved in that. So, but I will make notes if I see something to point out to the district judge that I think might be worthy of them looking at.
Let me just follow up on that.
Can I make a comment first
Sure.
for the record? I believe, particularly in my case and with my fellow judges, we are more qualified, not than the district judge, but the paralegal at the Federal Defender's Office. Additionally, I have tried 85 felony cases in this courthouse as a prosecutor. So I do understand that. I also, as a judge, do try criminal misdemeanor cases, including civil rights violations, which are, having done both felony and misdemeanor before I got here, I'm very attuned to that. I think I get it.
Sir, I think you, well, let me say this. I certainly know that Judge Goldberg isn't questioning whether or not you're experienced, or Judge Shirley, whether or not you're experienced and able to do it. But here's the thing. Throughout this country, when we have talked to folks, one of the things that judges say is that the reason that the voucher should be with them is because they're the ones who are familiar with the cases. The people came before them, the trial was held before them, they sentenced the folks, they read the memos, they did all of those things. They have the familiarity with the cases, and that's why it should not be placed somewhere else, whether they say in an administrative place, whether it be, I can't remember what they refer to, basically a third party, or whether it be with the Federal Defender's Office. The reason they say is because they're the ones who are familiar. So I think just elevating, I think Judge Goldberg's question, and yes, is more towards the issue of, if that is true, then
Let me see if I can
how would
answer
it
what I
be
think
that
your
in
concern
these
is.
two districts, and I'm sure other districts, that the magistrate judge is in a better position to be reviewing these vouchers when they're not the ones who are most familiar?
We are not usurping the district judge's review. We are assisting their review. Just like we have not seen what goes on after it leaves our court, they have not seen what goes on in our court. So that if I've had 6 to 8 motion hearings, how would they know what those look like? Whether they were standard, pro forma motions, whether they were very heavy lifting type suppression hearings or things like that. We just provide a recommendation. We don't usurp. They can do all the review they want, and there's not one thing we've done that takes that authority away from them.
In my understanding, and this could be a misunderstanding, but the understanding I had based on our earlier conversations was that essentially what goes up gets from the magistrate level to the district court judge gets affirmed.
I would like to think that every report and recommendation I send up gets affirmed.
Well, I know that may be true, but I'm talking about what
It's
the
not, but-
conversation we just had a few minutes ago was that essentially, and Judge Ott, you said maybe 10 times in the last, I can't remember how many years, but it was a decade, did it come back to you or questioned? And Judge Shirley, you indicated that usually it just goes up and gets affirmed. So
Well, I didn't say that. I just said it goes up hopefully for affirmance.
for affirmation.
Right. But I will agree that my historical experience is that there's a pretty good deference given to the 2 reviews that have preceded it. And I'm going to guess if the district judge signs off and it goes to the Sixth Circuit, there's a similar deference. But I don't know the extent to which they spend time reviewing our review.
And this is a question for both of you. Do the district court judges advise you if they cut a voucher?
It's come down to me, but it's been rare. I'm not sure I could call it up right now. I just kind of remember that being done. There was a cut made that I didn't recommend or didn't cut. I can think of one case, but it would be very anecdotal and
So there's no formal process? They don't send you a letter or an email saying, this is a voucher that you reviewed and I cut this?
No. Not,
Not, Judge Ott, that's the same
No,
for you?
it's not a formal process. We communicate very well about that. I would also say this, the way I see my role is to complement the ultimate decision of the district judge. As far as familiarity with the case, oftentimes I've actually spent more time with the defendant and the lawyer than the district judge does. For instance, I may handle motions to dismiss on an R&R, motions to suppress. The person then, after that, decides to plead guilty, even before the district judge has had to rule or review my work. They plead guilty and have a relatively short sentencing. So I may actually spend more time and have a very good feel for the case. Additionally, I cannot remember any time in my career as a judge that the 11th Circuit has reduced a voucher we have approved, ever.
Do they notify you when they do?
My courtroom deputy would know it. She would tell me. No, they do not personally give me notice. And you also have to remember, I have a relationship with the lawyers here, having practiced this long. I would know it.
Well, that brings me kind of to the next topic, and that is the issue of voucher reduction, and how is it that we know it? One of the criticisms has been, and Judge Shirley, you mentioned this earlier, is that the information is anecdotal. The problem is, if there is no solid data, if folks don't keep data, how do we know? So that brings me back to my questions, again, about voucher reduction. And I'm going to begin with you, Judge Shirley. In your statement, you stated that you thought that, or that your opinion was that voucher reduction was rare. And the question I have is, again, that seems, I assume that's anecdotal.
oh, yes. Well,
So the question I have is there any data in your district that you're aware of that actually indicates when, what a voucher request is, the amount requested, and the amount actually paid, the difference in them, and how many times that occurs?
yes.
And what is that data? And who keeps it?
I got a printout before I left, and I haven't really had time to decipher it, and I'm not sure it's in the best format because we have 3 different divisions. And
All right, so you said you got a printout, so I'm assuming that you haven't seen that data before.
I hadn't. And
And-
it seemed to comport with what I understood, and I didn't bring it. It's in my Expando file in the car.
All right? And where did you get that data, sir?
I had my clerk run it. I said, can you not my clerk, clerk of court. I said, can you possibly find me the vouchers and voucher requests and voucher actual payments, and then we can go through and highlight the ones that are different.
All right? And did they compile the numbers? I mean, does it actually say during 2015 there were 200 vouchers submitted in this district?
No, it's
and-
more of a spreadsheet, defendant Smith, and then across, voucher submitted, date, amount, submitted, amount, recommended, or paid.
All right.
And I think there might have been 8, if I remember right.
And over what time period was this?
That was like over one of the years. I just looked at quickly at the kind of yellow marks.
And can you provide that information to the committee?
I think so.
When you say,
Try to put it, I'll try to put it in a better format so you might be able to understand what you're looking at. If you see something that says Greenville or Chattanooga or Knoxville, but you see different magistrate judges, some of the way cases get assigned, I think I can get you the information you want. Might send it to you just in the format that I got it, or try to get it down and have a recapitulation sheet maybe. Total number submitted, total number cut, percentage cut, things like that.
does it also indicate, do you have any indicators on those documents that say why the voucher was cut?
No. But
you
if there's one on there for $9, you can probably assume that was something
Error.
technical, or $11 one, $25.29, something like that is probably not a.
And Judge Ott had said that when a voucher goes up from his district, an excess compensation voucher goes up to the Court of Appeals, that those vouchers do not get cut. Do you know if your district keeps any statistics as to whether or not their vouchers get cut at the Sixth Circuit?
Sixth Circuit, right.
Sixth Circuit.
I don't know if we do, and I, again, anecdotally don't know of any coming back. Technically, I think they come back for our payment, so there might be some way you could look at the amount submitted against, go over to the payment side of the courthouse and find out what the actual check cut was, and then do some analysis again. That might take a little time and heavy lifting, but
We have folks for that. Judge,
you might be making promises others can't keep.
I have confidence in them. They're young and energetic.
Oh, to be such.
Judge, I have the same question for you. Does your district have any information as to the voucher cuts for any period of time?
I don't know that. I made a note to myself also to check with the clerk of the court about that, because you've piqued my curiosity now.
And the second part of that question is about the Court of Appeals, the 11th Circuit in your situation. Do you know if the vouchers from the 11th Circuit come back to the district for payment?
Yes.
And so it's possible that you also may keep statistics on cuts from the 11th Circuit.
Could be. I just do not know that.
But are you willing to check and see, sir?
We can check and see.
Thank you.
Anything else? I have a couple questions, and I'll pass it to you. Let me ask, Judge Malazzo, you mentioned that you had sent one up to the circuit on, I think it was, has the one on the capital case, has that gone up yet? To the circuit on the case budgeting?
I believe it has, yes.
Okay. Do you know when you submitted it approximately?
Gosh, we just ran into another problem with this case, and it seems like it's been on hold for a time, unrelated to anything with budgeting. It has gone up, and it's been approved, and I just want to back up, because perhaps there was some misunderstanding as to the district judge is not reviewing the vouchers that come to us in terms of how our coordination with the Federal Defender's Office works. I am still provided the voucher. It is still my obligation to review it. They handle all technical deficiencies. It works through them. They're submitted to us through that office. But that does not mean that my obligation at that point, that anyone just signs off, particularly in those more complex cases where you're meeting with the attorneys. It's just, as far as I'm concerned, it just provides, for us, it seems to be an easier flow of information. But, I'm not having Ms. Daigle approve the voucher, so if there was some misunderstanding, I apologize. But no, I believe that voucher, that budget has been approved, and it was done some time ago. I don't remember. We just had a FOIA request that seemed to stop.
Okay, so I guess my question is, how long did the process take from the time that you submitted the case budget to the circuit for it to get back to you indicating that it had been approved? Do you recall?
I do not recall.
Do you know how, you've been there 4 months, do you know approximately how many you've had to submit to the circuit?
4 years.
4 years, I'm sorry.
Well, I think there were 3.
And were all 3 approved as you budgeted them?
Yes.
Okay. On the issue of travel costs, Judge Shirley, you mentioned that it's a big issue, and we've heard that around the country. How do you handle travel costs? In other words, we've heard different ways of handling it. Do you have a specific way of handling travel costs on your voucher?
Handling it, you mean in terms of trying to reduce it?
No, I'm talking about reviewing it. I mean, in other words, a remote detention site is, a certain distance away. Do you guys look at it and say, this is how long it takes to get there? Is there a particular way you look at it when you review it?
I guess yes. I mean, I know generally how long it probably takes. But I don't know if they got stuck in traffic. I mean, we have interstates that seem to be in a perpetual state of construction. There are, wrecks. There's all kinds of things. So if they said it took, longer, I don't question it. I trust them. Two things I do to try to reduce that cost is I try to encourage them to meet with their defendants when they're in town. So even if they're in for a hearing and they have a non-remote defendant, say they're coming a couple 100 miles or 100 miles for a hearing, they could go see their defendant while they're in town rather than make another 100-mile trip. Second would be to allow them often to appear by telephone. And so we allow them to come in that way. Now, certain hearings require them to be there with their client. And if I require that, then I ask them to get there early. So if a client's coming in from 200 miles, they're coming in from 100 miles, what a great opportunity to have one of those meetings you need to have with your client. But those are the two main cost-saving measures. The other is, it's hard for me to say. Now, one case I did compare where all the lawyers were kind of coming from the same downtown area, and one's bill was, completely different than the other by a substantial margin. And so,
And along those same lines, and I think
and what I got, by the way, is an answer, and I apologize for interrupting.
That's all right.
My secretary Googled it, and it said that's how far it was.
Okay. So along those same lines, and I think you might have indicated this, but do you know of any kind of training that your CJA attorneys receive about filling out vouchers? In other words, looking at this form and saying, oh my God, don't bill at 0.5, bill at 0.10 because it's just ridiculous, or the opposite, I want to see everything. Do they receive any kind of training about how to bill for travel, how to bill for in-court time, out-of-court time, or are they just given the vouchers and told to figure it out?
I would presume that they are offered the training. Again, our federal community defender, Beth Ford, will be here and she can answer that specifically. One of the issues that we've discussed on the panel administration is certain lawyers not taking advantage of the training opportunities. So I would guess they are there already in place. I just can't remember. I mean, we actually go over which of the training sessions are occurring, and I'm almost sure all of them have gone through e-voucher training. So I feel pretty comfortable saying yes. The extent to which it's stuck, I don't know, or whether they attended the ones that were offered, I can't say.
Do you have any requirements for attending a certain amount of training per year? You do? Okay. Same questions to you, Judge Ott. How do you handle travel costs?
Similar to Judge Shirley, the only other thing we do, because we have the marshals transporting prisoners to the extent we can, the marshal is also very accommodating about bringing someone in. For instance, if a lawyer can't make a 4-hour trip and we've got a trip already going, we'll put the defendant on the bus or the van. Other than that, we do it similarly. With regard to training, our federal defender has a very active training program where they get CLE for free. It includes voucher training. We also do the electronic voucher training by the clerk's office. So our lawyers are, I believe, are very well trained. That's probably why we have very few issues.
Okay, thank you. All right, Judge Fisher.
Thank you. Ms. Hunt, have you heard anything from your judges? First of all, I should ask, is it the chief judge of your circuit who reviews excess vouchers, or does he or she delegate?
Delegate.
Okay. Have you heard anything from those judges or the chief in the nature of, why are we doing this? We're not at the district level. We don't know what happened down there. Or the opposite. It's a good thing we're reviewing what those district judges do with these vouchers. Any thoughts?
My discussions right now, Judge Jane Stranch is the delegate to review the vouchers. I think she thinks it's an obligation that she has to do. I don't know that I've heard her comment on the value of that. I think that there is a fairly strong sentiment amongst those judges that I've spoken to, though, or who have weighed in on this with me, that they feel that they do add value to the process of reviewing the cases in the Court of Appeals. But again, I'm not sure how much value she feels that she adds, although because of our process, we route every excess voucher that comes to the Court of Appeals to the case budgeting attorney. So the case budgeting attorney does have sort of an objective review of what has happened in the district court.
Is that every excess voucher or?
The excess vouchers.
Okay. Not just the 30,000 suggested amount that's budgeted?
No, for any excess voucher that comes to the Court of Appeals, our case budgeting attorney reviews that for the delegated excess review voucher judge.
Thank you. Have the other judges heard anything anecdotally or directly, perhaps from any of the circuit judges who review vouchers about whether they think their positions or their review adds any value to the process? Judge Malazzo?
I really have no comment about that.
Okay. Any of? Okay.
I see them so rarely, and when I do, I don't think we're usually talking about vouchers.
Okay. Thank you. I don't have anything else, Judge Carter.
Could I ask the case budgeting attorney, what's that person's background?
He was a practicing attorney for many years. He practiced criminal law, and he became the case budgeting attorney on a pilot program in 2007. So he's been doing this for 8 years now, and his background was strictly as a criminal practitioner.
Do you know if he accepted CJA appointments, or was he?
I'm not really clear on his background.
Judge, could you, this may be a little bit off topic, but as I said, one of the many things I love about this assignment is you get to learn things about other districts. So as I understand it, you hear motions to suppress in criminal cases, prepare R&Rs. That's something we don't do in our district. So could you walk me through that a little bit? How often do you do that? And I think it's a great idea, and I'd like to hear a little bit more about it.
Having been on the court now for a number of years, we used to do it more than we do now. It's a very individualistic thing. If the district judge wants me to hear it, it's referred to me, I hear it. With the number of district judges, we have vacancies, 2 vacancies right now. One judge may send it down because he or she is in trial in another criminal case and needs it done. What happens is it's referred to me. I conduct a full-blown hearing. The lawyers present testimony, evidence, whatever. I would do a report and recommendation goes to the district judge. They have the opportunity to object. Oftentimes, honestly, there are no objections, and very quickly thereafter, the case pleads. So sometimes it's helpful. Other times, it creates another layer because there are a lot of objections that have to be reviewed by the district judge, depending on the nature of the case. We now have full civil authority. We're in the full draw of the court, so I do a lot more civil cases. I try probably 3 or 4 civil jury cases a year. So the district judges have been very good to us, and a lot of times they will keep those now to themselves, realizing that we have a lot of duties, which we do appreciate. But when necessary, they send them down, and that takes priority over everything else.
How many R&Rs on motions to suppress do you do a year? Just ballpark.
Now, probably, it depends. For instance, I'm working the federal death penalty case, so I'll do more work in that than I would in a typical criminal case. I would say on average, in the last 3 years, because it's really changed in the last 3 years, probably a dozen on motions to suppress. Motions to dismiss, probably less, definitely less.
I believe Dr. Rucker has a question, real quick.
Thank you, Judge Cardone. I want to address this question to all 3 of the judges, but initially to Judge Shirley. You indicated that you thought there should be perhaps maybe 2 statutory maximums. Would you care to share with us what you think the second maximum should be? And then I'd be very interested to hear what the other judges have to say about that as well.
In my notes to myself, I'd just put 15,000. Now, that's just a number out of the air. I have some thought in my mind that there are a number of these multi-defendant vouchers that come in that exceed 10, but don't really exceed 15. And so it would be nice if you could capture a large number of those that didn't go up to that level. I don't remember a whole lot over 15 in the 20. I mean, there's occasional ones, but I don't have a hard feeling on that number.
Okay, I just wondered, because you talked about sometimes the big data cases, the e-discovery that can be terabytes now.
I'm surprised that they aren't higher.
Judge Ott, do you have a feeling?
I agree. That little bump to 15, I think, would take care of a lot of additional cases. Where I find the excess comes in is in experts. That, you can spend $2,400, I believe it is now, on an expert in no time. Those always have to be approved. That number I would recommend be higher. I would recommend something something up to 5,000, for instance. With regard to psychological experts, it is very difficult to find someone that's going to do it for $2,500, $2,700 or less and give you what you need. I think 5,000 on expenses minimum would be reasonable.
Thank you. Judge Malazzo, do you have a thought on that?
I'll be honest with you, I hadn't thought of that until Judge Shirley discussed it. It sounds reasonable anecdotally, but I haven't looked at any data from my district. I'd probably be a little more comfortable having at least queried our judges to see what their view is. But it sounds reasonable anecdotally, and that's what I don't.
Okay, thank you. Let me, Judge Malazzo, stay with you for just one more question, if I may. With your public defender doing a lot of the work on the voucher review, are you aware of them making cuts or suggesting cuts, or working with the attorneys to cut their vouchers before they come up to you?
I have, and it has been things like travel. I've seen cuts where there's been a move because the travel was inconsistent. That's where, I'm trying to think of where I've looked at a voucher and there's been a cut, and it's been primarily in those sorts of things where it's not a, I wish that's where I specifically recall having seen problems or having seen changes to the voucher is in travel and things of that nature, not in preparation for a motion. I haven't seen that sort of cut. I know that when there is a preparation for a budget that's submitted, they do work through the defender's office, and I think there are conversations with the defender's office, and that's been my experience. But when the voucher comes to me, where I see cuts or in things that I would consider more technical.
Do the panel attorneys ever appeal to you about a cut that was made?
I've never had an appeal.
Okay.
About a cut. And that's what's been interesting is when I have talked to panel members, I think they've been satisfied with the process.
All right. Thank you very much. Thank you, Judge Carter.
Judge Prado.
As we've heard testimony around the country, the judges seem to say it's working fine, there's no problem. And then we hear from some of the CJA lawyers who tell us their vouchers are being cut without explanation, that there's this fear that if they're not super reasonable in their voucher, they might be kicked off the CJA panel. And so there seem to be inconsistent stories there between the judiciary and the lawyers, and I'm just wondering, it's difficult for us to find out, well, where is the problem? Is there a problem each district has its own different way of doing things, and we hear from each district, and it seems to be working in their district. So I don't know if the problem is inconsistency within the judiciary, that one judge is different from the others, and he or she says, heck, I got to worry about the national debt, so I'm going to cut them across the board. And so you have one judge in a district that is the problem, not the district. Or is it that every time there's a new chief judge who has a different outlook on things, that influences the district or the circuit? So I'm just wondering, where is the problem? Is it the individual judges that have problems and just a few of us? Or is it the way the system's done, and how do we remedy this? I know Professor Kerr had questions about regulations, and I don't think the last thing judges want is another ton of regulations telling us exactly how to do the voucher. I think we need some ability to do these on a discretionary way, but if there is an abuse by some of us, what are we going to do? And I'm just wondering if you would respond to those concerns.
I'll speak first. I don't know how to answer your question empirically at all. I think that's part of your charge, and I don't know how you'll do it. And part of my concern is anytime we talk about one size fits all with judges, it just never works. You have panels of judges who hear the same case, read the same things, and you have concurrences and dissents. They don't even agree on those types of things. If 20 district judges heard the same motion, I'm guessing they wouldn't all 20 rule the same way. If they see the same voucher, they may not see it the same way. As I read the reports, and this would be my commentary though, as I read the reports of some of the actual anecdotal problems that some lawyers had experienced, as opposed to the hypothetical problem that might happen, I was pretty taken aback by some of those accounts. And I would say if there are judge problems, then they should be addressed as judge problems and not be what is currently in vogue in the country, if I might make a commentary, that if you find a problem that's affecting 1%, we change the 99%. So that's why I wrote what I wrote, to say I don't think this is as big a problem as it is, but you're the ones touring and asking. My suggestion would be to, well, I don't know how you would do this, but go to the CJA panels in the various districts and say, how's it going for you? Do you think the judges are fair? Is it a judge you have a problem with it? Is it systemic in the division? Is it systemic in the district? Is it systemic in the nation? Or is this anecdotally a problem? I mean, you have some judges that tend to, magistrate judges, I know Judge Ott would know from our conferences, that are more inclined to detain people, and others that are more inclined to release them. There are those who view Fourth Amendment matters one way and some that view them the other. So I don't know how to answer your question other than that, except from my experience and talking with a large number of magistrate judges, many of whom operate the way we do, that there's no overarching sense that, you know, we need to cut these vouchers. And to the contrary, it's an obligation that we have been given, and we take it seriously. And I think that would be the general rule. Just as I said earlier on, not all CJA lawyers are saints, nor are all judges. And I suspect some have a mindset that say that, yeah, it was shocking to me. I thought they were when I was a lawyer. And I include myself in it. I suspect I've made mistakes along the way. I don't think, again, it's been systemic, but that would be the only way I can answer that question.
My suggestion, if I might very briefly, would be, I know some of our CJA panel attorneys, at least one, maybe two, have testified here or come before the committee. They probably would not publicly tell you whether we're cutting vouchers unreasonably or having difficulties there. I would suggest talking to Mr. Butler, our federal defender, and also talking to the Resource Council for each of the respective districts, so to speak, off the record, off the public record maybe, where they would be more inclined to tell you what they're really thinking. I would love to know if that's an issue in my district, because I would be astonished. Because they do good work, and we encourage that.
I believe, Professor, you have a question, Professor Gould.
Thank you, Judge. One quick question. Question for the three of you who are on the bench. Have either of you or any of you practiced elsewhere, or have you sat by designation elsewhere, so that you have an idea of whether the experience in your districts is similar or different from those in other areas?
I have not.
Nor have I.
Neither have I.
Okay, thank you. That's all I wanted to clarify.
All right. We're right. Did you have a question? Okay.
I just want to ask one question, and that is to kind of follow up on what we've just been talking about, the voucher cuts. Judge Shirley, one of the things that I read in your statement was that when you were looking at vouchers, you were obviously looking to see whether or not a voucher was an honest and forthright presentation of the services that were rendered. Am I to understand you correctly that if the voucher is honest, if everything in that voucher is something that the person did the attorney did in an effort to represent the client fully and effectively, that you believe that that voucher should be paid in full?
As a general rule, I would say yes.
And when you're thinking about an exception, tell me what you're thinking about.
I'm thinking about one case.
Okay. All right, then that truly is an exception. All right, as a general rule, if the work is done, the voucher should be paid.
Correct.
And Judge Ott, would you agree with that?
Yes.
Judge Malazzo? Thank you.
One quick question.
Yes.
In those e-discovery cases, and I would agree, those are generating a lot of fees. Do you ever get requests that paralegals do that rather than the lawyer, him or herself, which can reduce significantly the cost?
Again, we have had several of those requests. I've been surprised there haven't been more. There haven't been as many requests for some sort of a common coordinator of discovery for 50 defendants, where we could just pay one and attribute it to them. We've had paralegals, we've had IT support, we've had things like that, and I'm quick to approve those because I think that is a very good use of money, and it's usually well below the hourly rate for the lawyers doing the same thing. So I think it's a good idea, would encourage it. I just wish it was asked for more.
Would you take the initiative to call the parties in and tell them that that's what you're going to approve?
You know, I stick my nose in far more probably than most judges and more than I should, but I'm not sure I'd be comfortable telling them how to try their case. But if asked, I would, I wouldn't, if they said, do you think we could do this, I'd be encouraging and say yes.
One more, if I just follow. I'm sorry, Judge.
That's okay.
Do you know if the panel attorneys are being given CLE on this or providing any kind of education to help them handle these big discovery cases?
Again, I can't recall specifically. I would guess yes. If not, that's a good thing to do.
All right. All right. Thank you all for being here. Again, you can't imagine how helpful it is. We really, really are trying to gather information, and your information is invaluable. So thank you all for being here, from taking time out of your busy schedules. And we will go ahead and adjourn for 15 minutes. Our next panel begins at 9:45.
Thank you.